Welcome, everybody, and thank you for joining us this evening for our Estate Planning 203 session, which is all about estate taxes. And tonight we have a very special guest for you. We have Charles Telford III from Lippis Mathias. He's going to be going through a lot of the existing laws, the new proposed laws, and then a lot of the things that you can do to mitigate estate taxes. And we think about estate planning, you think about a lot of different things, taxes being only one facet of those things. And so if you are interested in the other estate planning sessions that we have done, whether it be about trusts or the basics or nursing home protection, those are all 100 level courses. We did a deeper dive on trusts last quarter. You can take a look at that. All of those are available in our TFG Academy section of our website at thefinancialguys.com. And for those that don't know me, my name is Glenn Wiggle. I'm one of the founders of the Financial Guys, and I am very pleased to present the estate planning courses to the public and to our clientele. And so I thank you again for joining us this evening. So Charles, let's just jump in and maybe you could kind of go down your bio. That might be a better if maybe you do it as opposed to me butchering it. So, but thank you for joining
sure. Well, first of all, thanks for having me. As you indicated, I do a lot of estate planning, and estate planning is really assessing what clients' needs are. What is it that they're trying to achieve at their deaths with respect to their families? It requires a certain amount of crystal ball gazing to try to predict the future and what families' needs are going to be. Being here in Buffalo, I have a little bit of I think kind of an interesting niche because being a border town, I do a fair amount of work with clients in Ontario and, strangely enough, Florida as well, because you get so many Canadians who either buy property in Florida, and we have a pretty robust office in Florida as well. But also there are a tremendous number of people, either US citizens who reside in Ontario or what I call mixed marriage couples, where one's a US person and one's a Canadian, and the complications that arise as a consequence of that, because just because you cross the border and you're a US citizen doesn't mean you shed your tax reporting obligations, both income tax and estate tax. So that's a very interesting area of the law. And I tend to focus and practice mostly on complicated estate planning type matters. I'm building the flux capacitor equivalent of the estate plan all the time. So that's what I do.
Perfect. Well, there's a lot of changes, obviously, when it comes to estate planning. So you're always kind of looking at new tricks and tools and things, and so there's a lot of opportunity to do planning, which is nice. So I think a lot of people feel as if, oh my God, you got this, big specter of taxes. And I think when people think about estate planning in general, I think taxes are usually the top of mind. And we maybe should have covered taxes in an earlier 100 level session, but again, there's so much to estate planning that we waited till 203 to get there. But especially now, Charles, with all of the changes being proposed, the 3-point-something trillion dollar, I don't know what they're even calling it now, infrastructure, stimulus, green energy, I don't know. But there's obviously a lot of tax implications with that. But before we get there, let's talk about the current set of laws that we have on the books, because I think there's a little bit of misconception when it comes to, what's available to kind of take off your estate at the federal level. And then also how maybe the state, New York State works into the equation.
Sure. Well, when you do estate planning work, it's not unlike being a plumber or a carpenter. You have certain tools in your toolbox, and you use some tools more frequently than others. And as we have listed in the slide, the predominant tool that we use is the unified credit. And the unified credit is a provision of the tax law that allows for the estate tax-free transfer of an enumerated amount of wealth. And for the last several years, we've had what's called an enhanced unified credit because under the Trump administration, the former unified credit was essentially doubled. So each individual, you and I and our listeners, would have roughly about an $11.7 million unified credit. So that means we could pass at death. And there would be gift tax implications as well that maybe we can talk about later. But you could give a little over $11 million per person, each of us as an individual, without having any estate tax implications. And of course, because each individual has that, a married couple, you would double that up and it would be more than $23 million worth of wealth. That law, even as it's written right now, unfortunately is a temporary measure and is otherwise scheduled to expire on January 1 of 2026 anyway. So a lot of clients who have very significant net worth have been planning in expectation of that law sunsetting and going away anyway, because that's kind of like the gamble that people are making, thinking that politicians will ultimately take the coward's way out. They'll just let it expire and then they can blame someone else for it going away and not being there anymore. But now the problem is that with all the things that are coming out of Washington, there's a lot of talk about changing the unified credit, cutting it in half or otherwise. And I think we'll get to that with the next slide. The other thing is a stepped up basis. Stepped up basis is a provision of the existing law wherein if a decedent, when they die and assets are treated as included in what's called their gross estate, those assets receive a new tax cost. So for example, if you bought a house in Orchard Park, probably in 1960, and you pay in Orchard Park and you paid $50,000 for it, that house today is probably worth, $800,000. And the benefit of having stepped up basis, of course, was that, let's say a parent died and they had that home, it was worth $800,000. $800,000 was well within the confines of the unified credit, so you didn't have any estate tax implications. But more importantly for the heirs, they're probably not going to keep the house. And since they had a new tax cost in it that was equal to the $800,000 fair market value or date of death tax cost, the house could be sold and you'd have no income tax implications because you wouldn't have a delta between the selling price and your tax cost in the property. And that's another provision that they're talking about now in Washington is eliminating stepped up basis.
I will say and we'll talk about the proposed law in a second, but when you look at some of these things like that, like getting rid of the step up in basis, the concern would of course be all these folks that have held and done 1031s and have held stock for so many years simply because they wanted to basically take the tax to the grave, so to speak, and allow their heirs to not pay the tax to get that step up. It is I guess you can call it a loophole in the tax code, but now they're going so far as not only to talk about taxing that as no longer allowing the step up, which I would fear would be, an immediate people starting to move around assets and sell some things. But now they're actually talking about taxing unrealized gains for high net worth individuals. And of course, when people think a high net worth individual think, oh, it's not going to affect me, that's Jeff Bezos. I can assure you it's you, right? And we're going to talk later in this presentation, if you're not at the level of 5 or 11 million, you're thinking, oh, this doesn't apply to me. We're going to show you some slides later about with asset growth in it to show you how easily a $1.5 million portfolio can turn into a tax situation later in life. So don't tune out.
Look at it this way. You're right. These seem like big numbers that if for an individual you have an $11.7 million unified credit or 23 for a married couple. But let's look at it this way. Let's say you were a single guy, you never married, but you had a lifelong career. Okay. And let's say they reduce the unified credit to $5 or $6 million. All right. And that still is a significant amount of money. But if you add in, say, life insurance, say you have $2 or $3 million worth of life insurance, which is not a heavy lift, right? And you add in your house and your 401k and your giant brokerage account that Glenn Wiggle has made grow tremendously over the years. Okay. It's not beyond the pale for many, many people to have more than $5 million. And a lot of people don't realize that they're worth as much as they do until they really sit down and they focus on it. So I agree with you 100% that it will hit more people than who they're counting on.
Eventually, exactly, eventually. So let's talk about the proposed law, because as you just alluded to, the politicians will most likely take the coward's way out. And unfortunately, all the things that are good for Americans, like allowing us to keep more of our money, they set those things up as temporary. So they expire. All the bad things like Obamacare, they stay with us for life, right? I think Ronald Reagan said it best, that the closest thing to eternal life is a government program or agency. And then, boy, he ever nailed that one. So let's talk about the expiration or the sunsetting of the tax bill that ultimately gave everybody this enhanced credit, because now things fall back to a much lower number, right, Charles?
Sure. So we already talked a little bit about the unified credit and whether they change it in the next couple of days, weeks, or months. Something's going to happen with the unified credit, and what you can count on is it's going to be less than what it is right now. If they go to the default and they do nothing, which I don't think is very likely, I think they are going to do something, because when you're spending money like drunken sailors, you've got to do something to raise more money to pay the bills. So the legislation that's been proposed has been to cut it in half. So you can see from the figures that are on the chart that if you cut it in half and you're being taxed at 40%, if you were an individual, you'd pay $2.3 million in added tax. And of course, if you had a married couple and the credit was otherwise doubled up, but cut in half now to basically, we'll call it $10 million, you're paying close to $5 million in estate tax. Now, one of the things that we didn't cover is repeal of the grantor trust rules, which is on the slide. The grantor trust rules are really a kind of a neat thing. People see things with respect to grantor trust and they might get alarmed because many times they're referred to as a defective grantor trust. And they think, oh, somebody screwed something up. But no, it's defective in a good way, if you can think of that. A grantor trust is a technique where a client can sell an asset to a trust. And the trust, of course, is treated as being a separate legal entity from the client. And because of the attributes of a grantor trust, when they sell the asset to the trust, it's not like if you were selling it to you or me, Glenn. It's as if they sold it to themselves. It's almost like they're schizophrenic, okay? And there isn't any income tax imposed upon it because you're treated as having sold it to yourself. And so as a consequence, what it allows you to do in most instances, it's a technique for purposes of fixing the value of an asset, which is a hedge against future appreciation and getting appreciation into the hands, let's say, of your children on an estate tax or gift tax-free basis. So, and the example we have here is, let's say you had a house or an apartment building or something like that, and you sold it to the trust for $800,000. Now, one thing to mention, I have $800,000 in the slide. If you were doing this, you have to sell it for whatever the actual market value is of the thing that you're selling it into the trust, because if it was less than the market value, you'd be making a gift for the difference, okay? So you'd sell it into the trust for fair market value, take back a note for the trust, in this example, to pay you $800,000, okay? And the trust, let's say it's an income producing asset like an apartment building, the income is going to be treated on your 1040, and you're going to use that income to pay off the $800,000 note. If that asset then appreciates, and say you die 8, 10, however many years later, that appreciation is not treated as included in your estate. It's going to go to the beneficiaries of the trust, and you fix the value at $800,000 in your estate. So it's a way of, if you could think about it, it's a way of taking an asset and monetizing it and allowing you to get the benefit of the asset at a fixed value and getting the appreciation to your kids. And this is one of the things that they're talking about just plain getting rid of it. And so as a consequence, we have a lot of people who are trying to get these types of things implemented as soon as possible, because when they've been talking about the legislation, at least thus far anyway, I don't know that they're going to apply any of these things retroactively, but then again, anything's possible, you just don't know. Right. But more likely than not, they're going to make these things effective as of January 1st. And at least in the case of grantor trust, they've said if you have the trust up and running and funded and effective in 2021, it'll be grandfathered in. But they'll always bury in the law somewhere that if you tweak it or make a change somewhere along the line, you may blow the grandfathering status. So you have to be careful with that too.
Right. I may have to talk to you between now and the end of the year myself. So, when they start to get into things like, taxing unrealized gains, nothing is off the table, right? In my opinion,
right.
I think that shows a level of desperation. There's no constitutionality that gives the government the power to just simply come in and tax, at least the federal government, unrealized gains. Now you have other taxes like property taxes on property that's not been sold. That's a different story. That's municipal, state, county, education, so on. But nevertheless, all right, let's move on.
Well, we could spend an entire, we could stop now. We could spend the entire presentation just slicing and dicing why a tax on unrealized gains. First of all, in my opinion, it's never going to, even if they enact it, It will never be implemented and they'll never collect anything. This is just a canard to get this bill through because they want to convince people that this is yet another way of paying for something and it's not going to cost you anything. The truth of the matter is this tax will never come to fruition and you will pay for it because it will blow a hole in the budget and you and I are going to have to pay for it. And if you want to talk at the end of the presentation from a constitutional perspective or otherwise why it won't happen, we can do that.
Yeah, we'll have to do that as a live presentation because my guess would be, in person, I should say, where we have the opportunity for the audience to interact with us, because my guess would be there'd be a lot of questions from the audience, and that would be something they definitely want to participate in. The downside with doing the Zoom, the upside to the Zoom is that we can, get to a broader audience in a more convenient way, right? So, folks can sit in their house, they can enjoy this in replay, they can easily attend, whether it's at work or at home or on their lazy boy and a laptop, which is great. The negative side of it is not doing it, in person, face to face, is you miss that interaction, which I'm sure at this point, the whole audience is nodding their head right now going, you are absolutely right. It's a budget gimmick to get things to balance off. So let's talk about another favorite subject of a lot of the, if we had audience participation, they would have questions here likely as well. And that comes to what happens with New York State estate taxes, right? Because
simple answer is nothing good. Nothing good.
Nothing good. No, never in New York State, nothing good, right? We know our viewers know this, believe you me. Our followers will absolutely are on the same page. No, nothing ever good in New York State. So tell us how this impacts New York and how does the New York State?
All right, well, let's first back up the bus a little bit. Most of the viewers, I'm sure they know this, but New York is one of the very few states that still has its own state estate tax. Most states, like Florida, have gotten rid of a state estate tax because they realize it's a regressive tax and it motivates people, big surprise, to leave the state and go someplace else.
Okay? I thought it was weather.
It's the only thing, right? That's it. So there's that. Also, it's been for a number of years, it's been a real problem for estate tax practitioners from a planning perspective to deal with this because there is a disparity between New York State estate tax and federal estate tax. We mentioned earlier the unified credit for federal purposes, you could call it the free amount for federal purposes, is over $11 million, at least it is now. Whereas New York is right now it's about $5.8, $5.9 million. And so without getting too far into the weeds, one of the problems that you could have is that if you wanted to fully fund a credit shelter trust or other disposition, if you did that, you would exceed the New York exemption amount and you would generate a tax, okay? Years ago, before this got out of kilter, there was a brief period of time, probably a mistake, where New York realized it's not a good idea for these two things to vary from one another. They should be the same to provide people more planning opportunities, but they allowed it to get out of kilter. And my fear is that New York is addicted to the opium of tax revenue, and they enjoyed the fact and they benefited from the fact. In fact, they even made it worse because they enacted what's called a fiscal cliff provision that under certain circumstances, you don't even get the benefit, you don't even get part of it. You don't get any benefit of the New York exemption under certain circumstances. And so New York is very much like every other tax that New York gets involved with. They're addicted to the estate tax. And my fear is that what's likely to happen is New York will sit and wait to see what happens with the federal law. And then after the dust settles with respect to that, they'll retool and figure out how do we optimize this, or how do we otherwise continue to benefit from New York State having an estate tax. So that's, I hope, not too long-winded of an explanation, but as I said earlier, whatever's going to happen with it, you can be guaranteed that it won't be anything good.
So two more questions along those same lines is, how is the unified credit portability, how would that be continued under the new legislation? Or would
well, I don't know. Obviously, we have what portability is, I guess, to explain that a little bit, is that for purposes of the federal unified credit, and this arises with married couples, if a spouse died and he or she did not utilize their full unified credit in whole or in part, When you filed an estate tax return, we have many estate tax returns where the return wasn't filed for purposes of remitting a tax. The only reason that we filed the return was because in order to get the benefit of portability, we were required to file a return. And what portability says is, spouse dies and doesn't use their credit in whole or in part, then the unused portion of it can be utilized by the surviving spouse. In fact, the way it works is if you make subsequent what would otherwise be taxable gifts, you actually consume the portability portion of the credit first before you even get to your own credit. And this is another problem, frankly, in dealing with New York State, because the two taxes are dissimilar. Federal law, you could use you have portability, but New York is a use it or lose it proposition from the perspective of the state exemption. So in other words, even though the exemption is less than the federal amount, 5.9 or 5.8, you still had to use it at the death of the first spouse. And if you didn't use it, let's say the surviving spouse gave 100% of his or her estate to the surviving spouse, it's not like the now surviving spouse, when he or she dies, for New York purposes, had a $10 million exemption. It doesn't work that way. No, it's just 5. It's just 5. And so that was yet another problem. Now, with the new legislation, it's not clear whether they're going to continue to have portability or not at the federal level. That remains to be seen. And as you said, who knows what they're going to do? Anything's possible if you're going to tax unrealized gains.
Right. Anything's possible. Yeah. If you're going to go that far.
That should be our theme. That should be our theme in this broadcast. Anything's possible.
Anything's possible. If they're gonna tax unrealized gains, they will go as far as they need to go, no doubt about it. So
let's just say from here on, AP just means anything possible. Just
that could have been the title of this whole presentation. That would have been funny. It would have been, if they're willing to tax your unrealized gains, anything is possible. But it does create a huge problem. I mean, just to go back to the previous slide for a second, you got issues to consider, like the step up basis. Does that go away? How does that work with New York? How does that jive with the unified credit?
Well, they've had a number of different proposals with stepped up basis. And again, I can't tell you how it's going to turn out. My crystal ball's in the shop with a blown tube. Okay. But it ranges from stepped up basis just goes away. So the good news is, okay, maybe the good news is you at least have some unified credit. So let's just make something up. Let's say the unified credit's $5 million. Okay. It may be you got $5 million worth of stuff that you don't have to pay estate tax on. That's the good news. The bad news is the $5 million worth of stuff you had has the same tax cost in it that your grandmother did, which is basically, zero. Okay, so if you sell it, you'll have an unbelievable income tax bill that you have to pay. One of the proposals was similar to that example. Let's say the credit is $5 million. What you would be allowed to do is on an asset by asset basis, you would take part of the credit and allocate it to each asset to eliminate built-in gain. Okay, up to $5 million worth of stuff. Okay, so let's say you had a stock that your grandmother paid $50 for, and it's now worth $1,000. You'd take part of the credit and say, okay, I'm allocating $950 worth of the credit to that specific asset. So now its new tax cost is $1,000, and I don't have any built-in gain in it if I sell it. And you just keep totaling all those things up, and once you got over 5, then you'd be done. You'd have no more credit to be used. I really don't know what they're going to do. I suppose whatever they do is whatever they think advantages them the most in terms of collecting the most tax, maybe.
Yeah. Could you imagine being the executor of your parents' estate and having to go through each and every security to figure out gains? And I mean, what a disaster.
Oh yeah. Yeah, and their linens and their china and everything. Crazy, it's crazy.
It is. So let's talk about some strategies, and this is a little bit of a use it or lose it kind of example. But you've got a good example here you put together on how some of the the gifting possibilities work, and there are some advantages to gifting earlier as opposed to waiting until later in life. So maybe walk through this example, Charles, and explain
sure.
how this works.
So where we are right now is, and where we've been probably for about the last year is. Clients have been thinking, because of what they read and what's going on in Washington, that it's a pretty safe bet that new legislation would be passed at some point this year and on banking on the fact that it wouldn't be retroactive, and therefore making gifts in 2021 that would optimize your unified credit while it's available. Okay, so in this example, I said father gifts has $7 million worth of assets and gives $6 million worth to the kids in 2021. No gift tax is paid, obviously, because as an individual, his credit, assuming he's never used any in the past, is 11.7, so fine, more than an adequate amount to preclude the $6 million from being subject to tax. Unfortunately, if the dad keeps the $1 million and they change the credit and it goes to less than 6 million, because that's what they've been talking about, 5,850,000, then because what he gave away in 2021 exceeds what the new credit would be, he'd start out in 2022 with 0 credit remaining. So as a consequence, if he wanted to gift or died and had the $1 million remaining, at a 40% rate of tax, you'd pay $400,000. Whereas if the father had given away the $1 million in 2021, wasn't banking on a miraculous recovery that didn't happen, it was like a deathbed transfer, would have saved $400,000 in this example. Now, the good news is, and I don't see how they can retreat from this, this has been published in a revenue procedure that the Internal Revenue Service published, I think it was probably about 2.5, maybe 3 years ago. If these changes that are embodied in this slide come to pass, there isn't going to be any kind of a clawback provision. In other words, if you went the full boat, let's say, and you gave away $11.7 million worth of stuff in 2021, and it turns out that in 2022, the unified credit is only $5.5 million or whatever it is, it's not like they're going to come at you and say, you gave away an excess $6 million worth of stuff, and now you have to pay tax on it. Internal Revenue Service has taken the position there is no clawback, so you're okay. But that's what's the incentive has been to people from a use it or lose it perspective, is that while it's there, try to take as much advantage of it as you can. Another thing that's worth mentioning is that years ago, New York also had a gift tax. People forget about that. And the gift tax, oddly enough, again, they must have made a mistake, clearly an oversight somewhere. The gift tax went away and we only have the estate tax right now. So from a New York perspective, gifting is irrelevant, other than, I think we cover this later on in the presentation, there is a 3-year rule in New York that if you give things away, you have to live at least 3 years beyond the point in time that you give it away, or oddly enough, if you die within the 3 years, it's treated as if you really never gave it away and it's back into your estate. And we can go into that more detail later.
Right. Well, whoever made that mistake on the gift tax, I'm sure got fired. So.
Oh, undoubtedly. They're with Jimmy Hoffa and the Giant Stadium.
Exactly. They were Clinton. So anyway, so again, I know this doesn't affect everybody on the call tonight or in the Zoom meeting, but there's a lot of folks that are in this situation that have $10 million, that have $20 million, that when you look at the income planning part of it, that's a lot of what we do at the financial guys. We do a lot of income planning, retirement planning for folks. There's oftentimes that we'll look at a financial plan and we'll say, well, you're never going to use this wealth. And if you are in a situation where, I think the assumed is it's going to go down to 5 million something. I think that's best case scenario in my mind. I think worst case scenario is they tweak it all the way down to a $3 million immediately, or even worse. I mean, let's remember, back in the 90s, when I started in the business, when Mike and I were first the wealth planning coordinators for Payne Weber back then, it was only a $600,000. Right. So, and everything over that was taxed at 40-something%. So we've come a long way in allowing, this is not the norm. This transfer of wealth from one generation to the other has really changed in the last, say, 20 or so years from what it used to be. And that's a big benefit to allow families to accumulate wealth and pass it on to the next generation, create that intergenerational wealth. Well, they can't have that in Washington, right? So they wanted to get their hands on that money. And this is one of the biggest ways for them to separate the American public from their money. And that's ultimately, I honestly think, no matter what side of the aisle you're on, that's what politicians wake up every single day with the focus on, is not how to make your life better, not how to, put better, infrastructure in place, not how to fix the roads and bridges. It's simply how do we drive more revenue to the federal government? And sadly, when you look at all the things, not to get off on a tangent here, but the things that they've done, the things that the government has gotten involved with, the quality has declined and the expense has skyrocketed, right? They're talking about getting involved in childcare now. And you look at it, whether education, college, or healthcare, I mean, it's pretty obvious that, they get involved, prices go up, quality declines, and that's really unfortunate. But anyway, for those that are not in this situation, let me just show you a quick slide of how you might very easily get there. This was an example I did for somebody based on some real numbers. This couple came into the office. They were, ready to retire at retirement age, about 66. And they had about $1.5 million invested in mainly IRAs. There's some other non-qualified assets, but mainly IRAs. And the expected rate of return, they were fairly aggressive with their money. And so we put a rate of return expectation about 8% into the equation. And, at 8%, 1.5, now this couple, by the way, I should mention, they didn't necessarily need their $1.5 million from their IRA for living purposes. This gentleman had a pension. They both had good Social Securities. They had both works. They both had solid Social Securities. And between the two of them, between Social Security and pensions, they were around $70,000 of income. So they really didn't need any income from their IRA, and thus they had the ability to be more aggressive and let it grow. Well, that $1.5 million at age 67, at age 99 turns into $7.1 million at an 8% rate of return. Now, again, this is a hypothetical illustration. Of course, past performance is never a guarantee of future results. But if you look at just simple historic stock market returns of 11%, it's very reasonable to expect over a long period of time, like a 30-year block, that you would return an 8% rate of return. So suddenly you're in a situation when you start at 1.5, no estate tax issue. Later in life, now at 7.1 million, now you do have an estate tax issue. If they bring it down to say 5 million or 5.8 million, suddenly you've got a $500,000 or $600,000 tax test due. And some people might say, well, but Glenn, I'm not planning on living till age 99. That's ridiculous. Okay, well, let's take a look at, in the same exact example, same scenario, 1.5 million tax deferred, earning 8%. When does that cross over 5 million? Well, age 86 and age 87. The couple was, I think they were 1 year off, right? So, that's not that far down the line, and they retired at 67. So 20 years later, in your mid 80s, which is very reasonable, you've got an estate tax issue. So you may not be in a situation today where you're not going to be affected by it, but you may be in the future. So it's really important to kind of go through the future planning from an income and retirement and future asset standpoint to kind of, look down the line at where you might be, because the sooner you can start planning, as Charles, you mentioned, if you can get some of these assets that you may not use into a trust or some other place where it can appreciate outside of your estate, maybe it's directly to your children. There's all kinds of options you have available, but those are things that you really want to think ahead on and not necessarily wait until you have a problem, because at that point you may be too old to qualify for certain things that we can do for you.
Time is never your friend with these things.
Yes, absolutely. So let's talk about some of those strategies. I mentioned your health, some things that you want to look at early. There are other tax mitigation strategies that we use. A life insurance and what we call an ILIT, which stands for Irrevocable Life Insurance Trust, is a very common way that we will do what I call either IRA replacement now that you can't stretch it for life, or a really tax replacement, right? You're allowing, an asset to be funneled out of your estate into a trust. That trust then buys a life insurance policy that can insure your life, that can either pay the taxes or go on to the next generation. So kind of walk me through this example on how that works. And
well, this is really kind of a low-hanging fruit sort of thing, I suppose, because I couldn't even begin to tell you how frequently, and a lot of estate planning is an educational curve too, I'm sure, as you know. You spend time with clients, and you don't necessarily immediately get something done. You have to get them up to speed so that they understand what's going on and get comfortable with it, and then they'll implement something. But many people don't realize that life insurance, the death benefit amount, is treated, if you die and you own the contract or have what's called incidence of ownership in the contract, the value of the death benefit is treated as being included in your estate. So you could have a 2 or 3 or 5 or 10 or however many $1 million life insurance contract, that the death benefit is going to be included in your estate. subject to tax of 40%. So you're going to take that haircut right off the top. So one of the real simple things for people to consider doing, because keep in mind too, with life insurance, it's never going to benefit you. So there's really no point in you holding on to it. Okay. You can only win by losing with life insurance. So really there's no downside to putting it into an irrevocable trust of this kind. And what you simply do is, if you had an existing contract, you set up the trust, the contract gets assigned to the trust. You typically have someone other than the insured acting as the trustee of the trust, because if the insured is the trustee, you may run the risk that you'd still have the policy treated as included in the estate, because it could be viewed as the decedent having retained too much control over the policy and therefore having incidents of ownership. If in fact it's a policy that you're still making, the payments still need to be made on it to maintain the contract in force, then what happens is that the trustee every year, let's say, the premiums are going to be due in November. Then in September, October, you let the grantor of the trust know that the premium is coming due. He or she writes a check to the trustee of the trust. Trustee of the trust then sends what are called crummy letters, which are not bad letters. They're named after Dr. Crummy, who was the person who litigated it at tax court. Great name, right? And you send these letters out to the people who are beneficiaries of the trust saying, you have the right to make a withdrawal from the trust, typically up to whatever the annual exclusion amount is. Now, no one really wants anyone to withdraw the money. It's just a technique to allow the grantor's annual exclusion for gift tax purposes to be used. Either 30 days elapses, or you check a box on the letter saying, I waive my right to withdraw the premium amount, and then the trustee writes a check to the carrier and the policy stays in force. And then unfortunately, when mom, dad, grandmother, whoever dies, the death benefit comes into the trust. And then depending upon what the trust says, and not included in the grantor or the insured's estate. And then depending upon what the trust says, the money goes somewhere. Maybe it gets distributed right away. Maybe it stays in the trust for beneficiaries for other reasons. Again, estate planning purposes, asset protection planning purposes. And in some cases, maybe if you have an estate where you think you're going to have a taxable estate and you didn't want the life insurance money being included in the estate and then compounding the problem by having tax on the tax with the insurance, the trust can loan money or maybe buy assets from the estate, and that generates liquidity to allow you to pay the estate tax. So it's a very useful tool. Have to follow the steps, have to do it the right way, because if you don't do it the right way, there's no point in doing it, because then you run the risk of an inclusion. But relatively simple to do, very cost effective, shouldn't be too expensive to implement in terms of having a trust done. But I say that in terms of a relatively simple trust. If you really want to build a really complicated mousetrap, the more complicated the mousetrap, the more the expense, but a very useful tool.
And, when it comes to life insurance, of course, you have to qualify, but please don't prejudge your health. I think a lot of people make that mistake. Oh, I'll never qualify. I'm too old. We've done miraculous things with people that have had heart attacks within the last 2 years. So don't prejudge your health. Let the experts do that for you. And of course, the financial guys, with our own Charlie Speranza in this case, as well as others, we have a whole team of experts that can, work with almost any insurance company in the country. So if it's possible to get you approved, if anybody can do it, we can do it for sure.
Another thing that's worth mentioning, Glenn, don't undercut yourself, is that there are policies and products that are available in Florida that aren't available in New York.
True.
And many times less expensive in Florida. And for all the people who have that, connection, that's something that's worth looking at too.
That's a great point. And we do that all the time. There are certain insurance companies that will just simply say it's where it's signed. Others have to have an address. Everyone's a little bit different in their rules and regs, but we have an office in Florida. We have advisors down there. We can meet you in Florida if that is indeed the rules. If you have a house, especially, or a place of residence, absolutely. Sometimes New York means well, I think, when it comes to insurance, but what they've done, for those that don't know, is they've required every insurance company, in order to do business in New York State, you are required to have a subsidiary in New York State. That's why on a national stage, you might buy a Jackson National policy, but in New York, it's Jackson National of New York policy.
Right.
And on a positive, that gives you more protection from an insolvency standpoint. However, it's very rare that insurance companies ever go insolvent. In fact, it's only happened a couple of times in my entire lifetime. One of which most recently, I think AIG, but before that, it was Executive Life during the savings and loan crisis in the 90s, right? So that's pretty rare. But the downside to it is that a lot of companies simply decide not to do business in New York. And so, places like Florida, even Pennsylvania, you have additional products and services that are available and special bells and whistles that you may not get in New York. So definitely something to look into if you are looking for, this as a solution, or just looking for life insurance in general for that matter. Know that we have multiple state registrations that we can work in depending on where you have houses or properties.
Can I just mention one other thing, because I think I mentioned it before, but I'm not sure. If you had an existing policy and you were going to use it to fund a life insurance trust and you live in New York, that policy is an asset and it is a transfer. So it's subject to the 3-year rule. Right. So you have to make sure, again, crystal ball gazing, that you're going to get beyond the 3 years.
Right. Well, one of the things that we recommend, and I was going to mention, is that if you are setting this up, let's say you are approaching this fresh and you're saying, you know what, I love this idea. I've got the assets to fund this, to make this happen. I got the health, all that's good stuff. You are always better off buying the life insurance in the trust to begin with. Mm-hmm. So set the trust up, have the trust as owner apply for the life insurance on your life, because you bypass some of those gifting issues.
Exactly.
So the setup is important. Don't go out and get the life insurance policy and then call Charles at Lippis Mathias, say, okay, I'm ready to go. I need that trust to put this into, because all you're doing is you're starting a 3-year clock that may, basically negate everything that you've done in the right way, except not quite right. Right. So keep that in mind.
Sequence is important.
Sequence is important. Absolutely. So, okay, so let's talk gifting rules. I mean, you mentioned this already a little bit. Anything else you want to add to the gifting part of this before we move on to some of the other uses of trust assets?
Well, I think we can jump into this in terms of trusts is sort of a general proposition and what they do and why we're talking about them with gift and estate tax planning. Probably the most important thing that's on that slide is the fact that in order for a trust to work from a gift or estate tax perspective, it has to be irrevocable. That means it can't be changed. Once it's done, it's done. And it also means once it's done from the perspective of you've made an irrevocable, you can't change it, the cement is dry, transfer of something into the trust. You're not going to get it back. And the reason why that's important is there are provisions in the Internal Revenue Code. The one that comes up the most frequently is something called Section 2036. And what it says is that if you make a transfer into a trust and everything looks good on paper, but nonetheless, you're doing certain things with respect to the asset or the administration of the trust that are impermissible, despite what it says on paper, the asset that you thought you got out of your estate and that went into the trust is nonetheless going to be treated as included in your estate. Probably the most common and a very simple example would be, oh, I have this expensive house. Why can't I just transfer the house into the trust and I'll continue to live, bless you, to live in the trust, in the house rather. And the problem is, and there's a fix for that actually, if you simply took the house and put it into the trust and nothing changed other than a paper shuffle, nothing really changed. Right. And the service is going to see through that and the house is going to be included in your estate. And by the way, when it's included, it's going to be included at the date of death value, not the value that it was transferred into the trust. So all the appreciation is going to be in there too. Now, if you did the same thing and you put the house into a trust and then you rented the house back from the trust and it was clear that you were paying fair market value rent, that there wasn't any disguised comp, and I'm not necessarily recommending that you would do this, but that would be the only way you could do it. You'd have to pay rent on the house because you don't own it and you can't treat it like it's yours anymore, okay? And that's the big thing with respect to trusts, both irrevocable in terms of the trust itself and irrevocable in terms of you're giving up the asset that was used or assets that went into the trust. And that's the only way it works. And the reason why it does work is then when you make the transfer into the trust, you use a portion of your unified credit in most instances, so you don't pay a gift tax. Once the trust is a separate legal entity owns that asset, then any subsequent appreciation accrues to the benefit of the trust and its beneficiaries rather than being included in your estate because you don't own it anymore.
Absolutely. All right, let's talk about some types of assets, because I think right along your lines, and we see this a lot, Charles, is that somebody comes to us and they say, okay, I want to open up all these new accounts. And a lot of our clients will come to us and they'll have done a very good job of kind of acquiring assets, I'll say. They got their 401k, they've done a good job of, putting some savings in the bank. They bought this product from this vendor at one point, they've got sort of thing. And so they get all this stuff together. And then, then they decide that, okay, I need a little bit more expertise. So I'm going to go and I'm going to get some, advice on the financial side, but I'm also going to do some estate planning. And I've heard a revocable trust is good or irrevocable trust is good. And then they go and they get the trust done. They think they're in good shape. And then they come to us and they say, we've chosen you as our firm because we know that you guys can bring all those different pieces of our life together in one cohesive retirement plan for us. And that's really what we need now. And I'll say, great, let's take a look at your statements. They'll say, oh, they're all titled in trust. And they start handing the trust over. I look at the trust. Okay, fine, put that aside. Then I start looking at statements. I say, well, this is in your name. It's not in the trust name. It's never been transferred into the trust. And so, not, worse than acting on paper as if it was just a paper transaction, owning the house or getting rid of the house, but still acting like it's your own. Even worse is oftentimes folks are thinking they have assets where they're supposed to be, but that final step of actually transferring and changing the ownership, even if it's a revocable trust, they don't get that done. So let's talk about, some of types of assets that work well within trust, because that's the other thing we see is people say, I have a revocable trust. I want to move everything there, whether it be irrevocable or revocable, doesn't matter. I want to put my cars in there and my gun collection and all these things. And that's not always the right idea when it comes to funding a trust, right?
Sure. Well, look, there's a lot of practicality that has to enter into these things, as well as legal analysis, and they go hand in glove with one another. If you're using a trust and the underlying purpose of the trust is estate planning, then as we've already discussed, the first thing that you'd have to cross is it something that you can afford to part with both financially, psychologically, and every other metric that you could apply to it. Optimally, if you're going to put something into a trust, the best thing to put into a trust would be something that is going to appreciate in value, because you want to get that appreciation out of your estate. And you want to get leverage out of your unified credit. If you're going to use $1 million worth of unified credit to transfer $1 million worth of assets into a trust, then you'd like to know that $1 million worth of stuff over some course of time is going to be worth 6 or 8 or 5 or whatever it is, $1 million. Certainly nothing that's going to depreciate, okay, or stay at a static load. Income producing is on the list of ideal assets, because if you're going to put things into a trust, there are costs to a trust, just like anything else. There's a cost to maintaining the trust. You have a tax return that you have to prepare. You have to pay your accountant. You may have to pay your lawyer. You have to pay commissions. And many times there's assets in the trust that require income to maintain them. So let's say you put your condominium into the trust rather, and you want that to be out of your estate. Well, the condo has to pay its common fees, it has to pay its taxes, it has to pay its insurance. Where's the money going to come from? There has to be income producing assets in it. Also, is it something that you can clearly and definitively substantiate that the ownership has in fact been transferred into the trust? Glenn, to your point, I couldn't tell you how many times people have come to me either prior to death or worse yet, their relatives after death with a splendid trust instrument that has all its fingers and toes and all the bells and whistles. The only problem with it is it's a dry trust. It was never funded prior to the person's death or disability. It doesn't do you any good. So you want to make sure that the things that go into it are things that typically have title documents or other evidence like stocks, bonds, real property, bank accounts, brokerage accounts, that there's no question that you killed a few trees, you have pieces of paper, and you can show that the trust owns it, okay? What's bad stuff to put into a trust? Well, on the list there, cars, boats, jewelry, for the reason I just said. Now, maybe you can title a car and a boat in a trust, okay? Granted, I'll give you that you could go to the DMV and probably do that. But cars and boats typically, other than things that are collectible cars and boats, they don't appreciate. They depreciate. And on top of that, they've been known to get into accidents and cause liabilities. And so if the trust owns those things and they generate a liability, now you get sued and the trust gets sued. And so to the extent that you were trying to do both asset protection planning and estate planning, maybe that went out the door. Unimproved real estate. We already covered. If it's unimproved real estate and it's generating any income, where's the money going to come from to pay the taxes and the insurance or otherwise? And that goes hand in glove with any asset that generates a liability without income to cover its costs. So you have to be prudent. You can't just back up the dump truck and pour everything into the trust, because it's just not a good idea.
Right. So this is where we're working with not only a qualified attorney, but a qualified investment professional that's going to dot those I's and cross those T's and really help to guide you along. Because, again, it's our job to change the titling of these assets, right? Not necessarily the attorney's job. So if you're looking for the attorney to do the work of getting the paperwork from the brokerage accounts and the investment accounts and things like that, that may not, be in their wheelhouse, versus in our world, that's what we do each and every day. Is we're always moving over assets, moving things around between spouses, between kids, between joint accounts. That's what we do. We know how to we have record keeping requirements that we have to verify that. And, always verify as well. It's another tip I'll give everybody, is that just because somebody says it's done doesn't mean it's done until it's done, right? So you change a beneficiary, and I can't tell you how many times this has happened. I changed that benefit. Just a sad case we actually had, which is one of our clients, but it wasn't our client, it was a client's relative, but it was the nephew of the client that was set to inherit this money. And what had happened is they changed, the beneficiary on an IRA, and nobody was aware of it because they never got the proper confirmation. And what happened was, I don't remember the brokers, doesn't matter who it was, but they never actually received it. There was no record. They filled it out, they signed it, they sent it in, but there was no record that it was ever received, and there was no record that it was ever done. You should be getting confirmation letters from whatever company you're working with, Fidelity, Schwab, we work with all of those different large firms, but you should get a confirmation. Your beneficiaries have been changed. Your titling of your asset has been changed. Got to have the confirmation to go along with the forms you submitted, just to close that loop, close that circle off, and make sure all the planning and the work that you and your legal team and your financial team have done for you is actually complete and solid the way it's supposed to be. So,
Glenn, I'll give you another real world horror story that I've encountered with people. Banks that are, and other financial institutions that are custodians of retirement accounts, IRAs predominantly, they don't necessarily have the legs that they used to in terms of remaining in existence. Not that they go away, but they get merged into other institutions.
Boy.
And you could have had your IRA that was with financial institution A, and now 3 iterations later, A has been gobbled up by C, okay? And by the way, you may not even really know, because you're still getting statements in the name of A, although A is now C, okay?
Yep.
And now someone dies, and you think you have a beneficiary designation in place, but unfortunately, somewhere between going from A to C, your paperwork went up into the vapors and it's gone, okay? And now you have no beneficiary designation. I agree with you 100%. The absolute best way to effectuate a beneficiary designation change is to write a cover letter and say, I'm enclosing the designation and a duplicate copy, and I want you to either sign or date stamp this copy and send it back to me with a duplicate copy of this cover letter, or sign and date stamp the cover letter acknowledging that you received the enclosed beneficiary designation. Because at least that way, if it does go up into the vapors and you had to litigate or otherwise, you've got a definitive basis to say, I submitted this, and they're probably going to have to honor it then. But you cannot take anything for granted, because you cannot.
Well, most quality companies, like Fidelity, like Schwab, the big institutions, they're going to send you a confirmation regardless if it's been done. Now, if you don't get
if it's been done.
If it's been done. So look for that confirmation. That way you have your own piece of paper. To your point, Charles, don't rely on them to keep that piece of paper, because as we've seen, all these mergers and acquisitions, there's no doubt about that. This is a very common thing that comes up when it comes to trusts in general, and that is, who do I pick? Who do I pick as my trustee? Who's supposed to, do I use a corporate trustee? Do I use my relative? Can I be my own trustee? And a lot of people want to be their own trustee, which obviously with their irrevocable trust is a no-go. So talk about, how they should consider going about the selection of the trustee that's going to be right for their particular trust? Because they might be different things to different people, right?
Oh, sure. I mean, the way it arises mostly in the client context is that I'm sitting across the table, most frequently from a married couple. And first of all, you got to talk about why is it that you think you need a trust? You know, maybe they're doing a trust for their children and they love their kids, but they think their kids need to be protected from themselves and everybody else. Okay. Or maybe they're minors that they're worried about dying young. And if they die young, who are we going to use as trustees for a trust or trusts for the kids? Then you start getting into the family tree most of the time. People start just reflexively, it's just human nature. Who do I know? Who am I close to? Who do I think I can trust that ought to be the trustee of the trust? And then you have to start sort of asking the probing questions with respect to the people that they've potentially nominated. Does X know anything about money? What's X's profession? Do they do anything that generates a risk? Are they just the kind of person that if it was at arm's length and it wasn't your brother or your brother-in-law or otherwise, is that the person you'd pick as a trustee? Because you really shouldn't just pick them because it's your brother or your brother-in-law most of the time. Okay, so there's that. What's the duration of the trust and what's the purpose of the trust? Obviously, if it's going to be a trust for relatively young people, you probably want to pick a person who has legs that are going to be long enough to go with the duration of the trust, or at the very least, pick one person that's going to get you from time increment A to B, and then have the successor named in there. And maybe, by the way, it's a person who's too young to do it now, but you're banking on the fact that by the time the first choice runs out of steam, the other person will be ready to be slotted and take over. So what's the duration? What's going into the trust? Are they going to be assets that require some kind of a specialized knowledge? You know, maybe you have an apartment building or something like that, and you've been running it with your brother, and he knows a lot about the business too. Well, then fine. Maybe he's a good choice to have that to be the trustee of that trust, because he has to both run the trust as a trustee and he has responsibility for the asset in the trust, which is a business in and of itself. And then the last one I had on the list is deep pockets and experience. My own sort of bias in many cases is I like institutional trustees for a couple of different reasons. One is no one wants to have problems. You're not picking a trustee because you want to have a problem. More likely than not, an institutional trustee isn't going to have a problem because by definition, they know what they're doing because they manage money. They're a trustee by profession. That's what they do, okay? However, if it does turn out that something goes wrong, who would you rather sue? Your idiot brother-in-law who doesn't have one dime to rub against the other, who has a higher chance of having a problem, or would you rather, and I'm not advocating lawsuits, don't get me wrong, but if you had to sue someone, you'd rather sue an institution that has deep pockets that can make good on a mistake than someone who can't, because it's wonderful to have a lawsuit and have recourse, but if there's no money to pay the judgment, it doesn't really do you a whole lot of good.
That's right. Exactly. Let's talk about some common trust problems. And this is something that, certainly is a big part of it is, understanding, the irrevocable nature of the gift, right? A lot of clients just simply don't want to, put something into a trust that they can't take back. And that becomes a bit of an issue between, and I get it. I mean, you get to a point and you've accumulated all this wealth. You did it for yourself and your spouse oftentimes. And then there's that concern about, boy, if I give this up, what if I need it? And that's always a hurdle that we have to get past. But that's not the only hurdle we have to get past.
No, I think that most lawyers who practice estate planning and financial people like you, Glenn, we spend at least half our time practicing psychiatry without a license, okay? And this is really an exemplification of that, is that you have to get people in the right spot mentally to be able to accept, embrace what it is that you're advocating and why you're advocating it. And as we've said many times during this presentation, the irrevocable aspect of things is often an aspect that people have a hard time getting past because they just don't want to part ways with something. Probably the worst example of that and I'm not blaming people, is someone that has a closely held business, that they've been the captain of the ship for a very long time. They've built it up, and it's very hard for them to get to the point of saying, I'm comfortable with the fact putting this into a trust, or maybe even transferring it directly to their children, maybe not a trust at all, and losing control. So irrevocability and the control part of it. The slide there says, it talks about a child as a beneficiary and behavioral issues and a trust being detrimental. Most people set up a trust for good altruistic reasons. They're thinking that I'm doing this trust and it's going to provide revenue and capital and resources that's going to help a person. But sometimes if a person has contrary behaviors, having access to resources is like putting gas on a raging fire. It's not a good idea for them to have access to money. So you have to design a trust, hopefully, looking down the road to have attributes to it that can address these things, because circumstances change and you want to have the flexibility to be able to deal with those changed circumstances. So I think that's our next slide, is what do we do about that?
Exactly. Yeah, because that is something that you can do something about. It's not the easiest thing to do, but it is, there is possibilities for everything. We'll say it that way, right?
Right. Now, as much as I've said throughout this presentation, I've used the term irrevocable, and you can't change it, okay? Lawyers are lawyers, and they're always thinking about things, about how you can actually do things, okay? And so here's some examples, okay? Decanting is either a statutory technique, or sometimes the what's called decanting language is actually embodied in a trust. And decanting, the analogy comes from decanting, just like wine, where you take wine and you pour it from a bottle into a carafe, and you do that to allow it to breathe, and it makes the wine more pleasant to drink. Same kind of thing with the trust. There are state laws, for instance, both in Florida and in New York, where you can, under certain circumstances, take a trust that's otherwise irrevocable, and you can pour it into a new trust that has perhaps changed terms from the existing trust. And sometimes we use decanting to cure defects. And sometimes we use decanting to make changes because of the behavioral or other circumstances that we talked about before. Sometimes we use it for all of those things and for tax planning purposes too. We also sometimes use, the next provision there is change of situs. That just means location. And situs from a trust perspective means if I initially formed a trust in New York and it's a New York trust, the governance of the trust from an administrative and an interpretive perspective is subject to New York law. But you can sometimes change the situs of a trust so that it's interpreted under the law of a different state. And it may be that the other state has more liberal terms in a good way, not the usual way we think of liberal, okay? and so you may have a New York trust that's subject to New York law, and you could use the New York decanting statute to put a change of situs clause in the New York trust, and then the trustee presses the button and effectuates the change of situs and says, guess what? I'm moving the trust to Florida. And then maybe you'll decant the trust again under Florida law to change its terms and cure a problem. Another provision that's on the slide is include a broad class of beneficiaries. So maybe rather than having a trust that specifies a specific person or persons by name who are beneficiaries, maybe it's a class of people. Maybe you say it's Glenn Wiggles' issue. That's a complicated lawyer's way of saying your children, your children's children, etc. And maybe if you designate a class of beneficiaries, and it's a broad class, you're not hemmed in and required to just make a distribution to a specific person, but you can make it to multiple different people, or none of them, or only one of them at different generational levels, so that if the person who you really intended to be initially the beneficiary turns out to be a bad penny, you don't have to favor the bad penny. You can have the money go someplace else. And another provision that's not on the slide that I should have thought of, there's something called a trust protector. And that's a relatively new provision in the law, but many trust agreements include designating a person as what's called a trust protector. And the trust protector, and where that originated from, was originally people put in a designated person who could make tax law changes to a trust. So in other words, I write a trust today, incumbent upon what the law is, but I included a provision that says that the trust protector, even though the trust is otherwise irrevocable, can make changes to the trust to make it compliant with the tax law so that it continues to achieve the grantor's original objective. And then that's been expanded over the years that the trust protector can do other things like change the situs, decant the trust, add beneficiaries, subtract beneficiaries, all kinds of different things. So that's a very powerful thing to build into a trust too. So there is flexibility even in irrevocable trusts, and you try to build into them as many features as you possibly reasonably can foresee that you might need, because as we said, AP, that's our new thing. Anything's possible. It's probably more important than ever, and it's a process of talking to the clients, getting them up to speed, telling them the stuff that's available, making sure they understand it, and then going forward from there.
Absolutely. I mean, some of the stuff is very complex. I know, and obviously when you hear irrevocable, it makes you nervous, but there are ways that, as we just went through, to make changes. I mean, our goal, both from, a legal standpoint, a financial standpoint, is really twofold. Number one, make sure that your wishes are being executed, right? So make sure as a client, your wishes, whether it be money going to a charity, a foundation, kids, grandkids, whatever, making sure what you want to happen with your estate is proper and set up properly so it happens the way you want it to happen. That's number one. Number two for us is keep as much money in your family pocket as we can and as much away from the IRS as we can. So the whole game here, especially with this entire presentation, is, how can we keep that wealth inside of your family or whatever you want it to go to? Again, whether it's a charity, foundation, friend, whatever, it's your wealth and your decision to make. But the ideal scenario, I've not met one person in my entire, almost 30-year career now that has said, I want to pay the IRS as much as I can. I don't want to do anything because I want the IRS to be my biggest beneficiary. Of course, nobody says that. I'm not as much as some of these liberals like Warren
if they did say that, you probably shouldn't let them sign the document because there's probably a capacity issue. So
right, exactly. I mean, even folks like Warren
mental
Buffett.
competency.
Yeah, even folks like, exactly. Even folks like Warren Buffett, though, that profess to say, we should all be paying more taxes, engages in tax mitigation strategies to avoid those very same taxes that he professes to want everyone to pay, right? He gifted $40 billion to the Bill and Melinda Gates Foundation. Why? To get that out of his estate, right? I mean, if he truly thought that the government could do better with his money than he could, or Bill and Melinda Gates could, then he would have written that check to the IRS. And look, I'm not, I am anti-paying taxes, but everyone has to pay taxes. We all have to pay our fair share, but we don't have to pay more than our fair share. And unfortunately, I think that most of the government spending is wasteful. I think we all know that, right? And so if the government did a great job with our money, or as good of a job as we did with our money, it would be a different story. But I think Milton Friedman said it best. He summed it up in 4 ways that money can be spent, right? You can spend your money on somebody else, right? You can gift it to somebody else, or you can spend money to buy somebody else something, right? So you're concerned about cost, but maybe not as much about quality because it's for somebody else, right? You can use somebody else's money on yourself, right? That maybe you go out to lunch on the boss's credit card, right? Now you're concerned about quality, but not so much concerned about cost, right? So order the steak, the highest, the best restaurant, whatever, because cost doesn't matter quite as much, right? You can spend, your money on yourself, which in that case, quality and cost is important because you want a good value for what you're buying and you want something that's a quality. And lastly, you can spend other people's money on other people. And in that scenario, neither cost nor quality matters. That's our federal government right there in a nutshell, right? They're spending other
not your money
on other people,
right?
And so when it comes to other people and other people's money, cost and quality neither matter. And as a result, you've seen wasteful spending and things get more expensive. So anyway, but I digress. Let's finish up here and wrap this up. I know we've covered most of this. We covered a 3-year rule with New York State estate tax. This is going to be, I think, probably one of the last a big question that maybe we didn't cover. And that is, how does the residency work for tax planning? Like if I escape New York and I move to Florida or Texas and then I die, are they pulling me back in? Is there a time I have to be out of New York? I know a lot of folks are thinking about this. I'm going to retire, then I'm going to leave. How does the state residency work out? And is there anything else that I may have missed?
Wow. Well, we could spend, again, it's another one of those topics. We could do a whole separate presentation, maybe a series of presentations on that. Residency tax planning, most people approach that from the perspective, at least initially, as they're leaving New York State to get away from paying New York State income tax, okay? And most of the time, if you're leaving New York to not pay income tax, and it's not always the case, people don't leave a fingerprint behind in New York. Okay, if they're really doing it the right way, that means they've severed their ties, and it typically means they don't have a home or an abode or a place to stay in New York anymore, and they've really moved lock, stock, and barrel to Florida, okay, or some other state. I'm just picking Florida to illustrate the point. If in fact it's demonstrable and provable that you are now domiciled in Florida, okay, then in theory anyway, when you die, you're not going to have any New York State estate tax exposures. Now, again, the fingerprint part of it is important because let's just say for purposes of argument that even New York accepts the proposition that at your death, you're not a resident here anymore. If you have at death, you leave behind in New York what would be considered to be New York situs or assets located in New York, your estate may still have an obligation to pay New York State estate tax. So for instance, if you had a beautiful home on the Finger Lakes that you owned at death and it was worth $7 or $8 million, your estate would have to pay New York State estate tax because that property, obviously it's real property that's located in New York. It's going to be treated as your New York situs and a New York estate tax is due. And if it was worth $5, $6, $8 million, then it's well in excess of the exemption amount. Okay. More commonly, we see situations where maybe people have a small place that they stay part of the summer, maybe in Western New York, and its value is not anywhere close to anything like that. Maybe it's a couple $100,000. Okay. You'd still have to file a New York State estate tax return just to report the existence of the asset, but you wouldn't pay any estate tax on it because you have a full, basically $5 million New York exemption. I still worry when people leave any kind of a fingerprint behind because that's just the way I am, that any kind of a piece of paper that you have to file with the state is going to give them a toehold to examine. And where does that lead and where does the trail of breadcrumbs go back to? When you're doing your residency planning and you're exiting from New York and you're establishing residency someplace else, people tend to think that's a one and done kind of thing. They even think it's one and done if they were audited, okay? And that's not true. You in theory, for every year for the rest of your life until you're dead, you could still be examined by New York State to prove that you're not a resident anymore, okay? And then they get a final bite at the apple at your death because the estate tax return is totally different from the income tax return, which is yet another reason why I think that if you do really leave New York and you don't leave the fingerprint behind and you don't have to file a New York return, paper is usually the thing that hangs you. And if you're not generating paper, then there's a much less chance that you're going to have a problem at death. Okay. So I'm sorry, that's a long-winded explanation, but it's a detailed thing. It's the only way to answer it. Okay.
Yeah, and when it comes to income taxes, we did a whole nother presentation on escaping New York and changing residency. I think it was with Alejandro. We've done several different estate planning. As I mentioned, we have a whole 100 level series, and this is the third in our 200 level series. We get more complex as we go. And so again, if you want to go back and walk through the different things that you have to do to establish a different state residency, then I would encourage you to go back to our website, thefinancialguys.com, and you'll find under TFG Academy all of those different sessions that we've done, including the escape. I think we called it Escape New York, coincidentally. So,
Charles, like Snake Plissken? Snake Plissken, right?
Snake Plissken, yeah, exactly. Yep, exactly. You're same generation as I am. So that's I keep joking that eventually they are going to build a wall around New York and there'll be an exit tax to exit it out. It'll happen in New York City first, no doubt.
Right.
Anyway, well, Charles, thanks so much for joining me tonight. I really do appreciate it.
Oh,
And
this is fun. Thank you for having me.
folks, a lot of you know who we are already, and I do appreciate you being clients and following us, whether it be on the radio for 20 some odd years or being, part of our clientele and really family at the Financial Guys. For those of you that don't know us, we are a one-stop financial shop. So not only do we do estate planning, but we do retirement planning, which is really our bread and butter. We do a lot of income planning. We have certified Social Security claiming strategists to focus on just Social Security. We have a Medicare department that can help you with Medicare. We do home and auto because obviously if you don't protect the assets from liability, they could go away as well. And so you got to make sure you got that covered also, and much, much more, way too much to mention. Go to our website, thefinancialguys.com, to find out all of our different departments and the things that we do. If you have questions or would like additional information, you can always email us at contact@financialguys.com, or again, go right to our website. There's a contact button right there at thefinancialguys.com. Or of course, you can always call our office, which is 833-346-4897, which actually stands for 833 Fin Guys, FIN Guys. So you can remember it that way. Okay. And then finally, after this presentation tonight, you will receive very shortly a feedback form where you can request an appointment, ask for additional information, or ask to be contacted for additional questions that you may have. And of course, your feedback. We want to have your feedback. So please, 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 let us know how you like tonight's presentation. I know it went a little bit longer than our normal hour, but obviously when it comes to estate planning, especially tax mitigation strategies, there's a lot to cover, and probably another hour we could, Stephen, still do, as Charles, you mentioned. So thanks for your patience tonight. I appreciate your time, and I look forward to seeing everybody in the future. Thanks again for listening, and I look forward to seeing you in our upcoming estate planning. I guess it'll be 204 will be the next one. So we'll see you then. Have a great evening.
Thank you.